incited him to do so. True, in both situations a fair trial could take place, but given that there should have been no trial at all, the imperative consideration became the vindication of the rule of law. And that's why we submit that when one applies the Latif test and cognizant of the fact that the case against the third respondent, the prosecution as a whole, was not implicated, contaminated, or undermined in any way by the conduct in question, the decision to discontinue it became inexplicable. We have not dealt with the 179 argument at all at this stage in view of the indication we've received from counsel for the NPA as to what approach is being taken. If it's necessary, we'll deal with that in due course. Those are the submissions on behalf of the applicant. We submit for relief in the form sought in the notice of motion, the setting aside of the decision in question, with costs, including the costs of free counsel. Those are our submissions.
On the other ground that you've raised of legality, do you have further submissions to make, especially considering what your colleagues have considered on?
On the legality
yes.
challenge? No, we don't have further submissions to make on that score at this stage. We've confined ourselves to the rationality of the decision. We haven't made any submissions or taken the submissions in our heads of argument any further in relation to whether or not a decision of this kind to discontinue a prosecution is administrative action or not. For the purposes of our submissions, we have contended it's not necessary to resolve that question.
Okay. Thank you very much, Mr. Rosenberg. Or do you wish to say anything further?
I was looking around one other piece of paper, but I can deal with that in reply if needs be. As the court
Thank you very much. Mr. Epstein.
I'll start with stating the following. Mr. Zuma was to be recharged. That is to say, whether this should occur before or after the ANC's national conference held in Polokwane during December 2007. This was plainly most irregular and worthy of strong criticism. And again, the irregularity of Mr. McCarthy's conduct is not to be minimized. Now, I've stated that, and although I agree with that, it's not a submission that I make. That comes directly out of the DA's own founding affidavit. Mr. Self says in his founding affidavit at page 38, and if I may repeat it, to the degree that Mr. McCarthy was a party to manipulating the timing of exactly when Mr. Zuma was to be recharged, that is to say, whether this should occur before or after the ANC's national conference held in Polokwane during December 2007, this was plainly most irregular and worthy of strong criticism. And at page 39 of the founding affidavit, Mr. Self says, who's the deponent of the founding affidavit, again, the irregularity of Mr. McCarthy's conduct is not to be minimized, which we submit is what the DA has sought to do today, to try and minimize the conduct in the face of the statement by Mr. Self in his own affidavit that it is worthy of strong criticism and should not be minimized. It was a most serious abuse which I will deal with later when I deal in depth with the facts.
Just raise this. In the affidavit of Mr. Hofmeyer, he's making references to a number of people, including Mr. McCarthy. Now, the allegations that are raised against Mr. McCarthy, Mr. Nuka, Mr. Casrels, President Beki, how do we deal with this? Have these people been served with a document to give their views on what is being alleged against them? Because I don't know, what is the veracity of these allegations if the other parties have not been given an opportunity to respond to them and tell us whether they agree or not? That's the difficulty I have. Because if we are to say the decision taken by Mr. Mche was based on what he heard in the tape, one would imagine that the people who are implicated should have been given an opportunity to explain their actions before such allegations could be raised under oath in the papers. So I don't know. You help me out on that one. I have a difficulty with it.
Well, Justice Motley, firstly, they are not parties to this case. Secondly, Mr. Nuka was given an opportunity. He was, it's in the papers that the questions were put to him and he gave a response. Mr. McCarthy was invited to respond and he elected not to do so. He was in place which he then wanted determined before he would respond. And can I, in the same vein, refer to the following? In the judgment of Nicholson J. In 2008, there was strong reference to President Mbeki, and President Mbeki felt that he had been maligned by Nicholson J. And the matter then went on appeal to the Supreme Court of Appeal, and in that application, President Mbeki sought to intervene, and Haram's deputy president at the time, he said that he had no right to intervene. He is in no different position from a witness in a case who has been defamed or maligned, and he's not a party and he has no right to intervene. So this isn't a case about McCarthy being a party or Nuka being a party. They are referred to. It was open to everybody if they could get a response from them, including the DA, to approach them, get affidavits from them. And the fact is that what is on the tapes are recordings rather, of conversations between, inter alia, Nuka and McCarthy. And earlier on, the question was put to Mr. Rosenberg as to whether that's not a question of interpretation for the court. Well, we're not dealing with a document, where we know the law is that documents are, when to be interpreted, while there are rules of which may be used in aid of interpretation, ultimate interpretation is a matter for the court. But here we're talking about actual conversations which have simply been reduced to writing and transcript. And they do not constitute the entire conversation from beginning to end. The relevant extracts were taken by Mshe and put into his reasons. So the question of interpretation is not simply something which the court can look at in isolation. And like with interpretation of contracts, interpretation must be done within context. And there is a very large context to what is being said. And in order to understand what is being said, one needs to know what the context was, what Mr. McCarthy's role was. He was obviously he was head of the Directorate of Special Operations, and it was a very, very high position that he had, and he managed the prosecution. We don't say that he took the decision. It was a collaborative decision. It was what has been referred to as a corporate decision. But he played the major role. He was central to this entire process. So, Justice Motley, our submission is that those parties do not have a right to be here. If they wanted to, they could have approached either of the parties and said they want to file affidavits. And insofar as there may be a dispute as to what the meaning is of the recordings and how they were interpreted, well, then the applicant could have asked for that to go to oral evidence. And then the procedures could have been used to possibly subpoena them if they didn't come voluntarily, and they could have been cross-examined. But they haven't chosen to do so. Mr. McCarthy, who's now head of integrity of the World Bank, I understand, is far away and not coming anywhere near this court. So our submission is that it's something which this court must, and with respect, should take into account.
Yes, I hear what you're saying, but then there's a reference in the first respondent's affidavit to some theories that seem not to find support of the record, that when Mr. Nuka spoke to Mr. McCarthy, who then spoke to Mr. Casrels, and presumably it went to Mr. Mbeki, there seems to be no proof that such meetings were held. And that's my concern, that we cannot, that kind of evidence, you don't find it on the tapes. It was a statement by the deponent giving his theory of what could have happened. And I raise it because, as you heard the applicants indicate, that Mr. Mpie, when he took a decision, he said that President Mbeki might be involved behind the curtains. Now, if you take that statement and link it to what Mr. Hofmeyer is saying, he's stating them as a matter of fact. That's why I have a concern. I want to know whether indeed there were such meetings which Mr. Hofmeyer knows of, where Mr. Mbeki was present, and if that is the case, why he was not given an opportunity to state them. That's all I want to know.
There are direct statements by Hofmeyer as to discussions that he had with Ngcuka, and about where Hofmeyer was accused of failing in his duty to protect President Mbeki. And there are a number of references. It's true that assumptions are made, but the applicant brought this application. They've chosen not to ask for it to be referred to oral evidence. They're bound by the Plascon Evans rule. And if the court can't make a determination on that, well, then that's the problem, because that's the route they chose to take. But one can't do further from the respondent's point of view when all you've got is the recordings and you don't have access to Mr. McCarthy, and you can't force Mr. McCarthy to explain what happened. The best one can do is refer to the background, which I'm going to deal with, and which I submit will show overwhelmingly that that President that Ngcuka and McCarthy were doing this in order to try and ensure that President Mbeki was successful at Polokwane.
We'll take it up on argument tomorrow. I just want to pursue this because if reference is made of a meeting with Mr. Mbeki, it's different from saying that certain two parties were doing it to advantage him. Was he aware? Was he involved? That's the nub of the question. If he was, where's the evidence to that effect? If he wasn't, then an allegation cannot be made that he was, in fact, party to the proceedings when it cannot be supported by document.
No, yeah, I do. Justice Motley, can I deal with this this way? There's no suggestion, and there's no evidence that President Mbeki himself was conspiratorial in this prosecution. The point is that McCarthy and Ngcuka, with or without the assistance of President Mbeki, were proceeding with one agenda and one motive, and that was to try and ensure that President Mbeki was successful at Polokwane. So there's no evidence that President Mbeki was involved in this, but it's what McCarthy was doing. And I will endeavor to show you that the conclusion is inescapable, that McCarthy was doing this with one point in mind, and that he was manipulating the prosecutorial process for a political agenda that he had and that Ngilka had. Can I also, in the same vein as I started, refer to what a memorandum by Mr. Downer, who was the head of the prosecution team, which is at D209. If I can put this in context before I refer to the relevant portion. What had happened was by on the 4th of December, Mr. Mshe had contacted Mr. Downer to say there's a possibility that the serving of the indictment might be delayed. And Mr. Downer was not happy with that, and 2 days later, on the 6th of December, Mshe phoned down and said, the decision has been made, it's going to be postponed. And Mr. Downer was very angry indeed, and he said, I'm going to do a memorandum. And this is the memorandum that he does at page 209. You'll see the subject is delay of the announcement of the decision to charge Zuma and Tint. And if I may take you to paragraph 7 of Downer's memorandum, which is addressed to the acting NDPP, which was Mshe. He says from paragraph 7, in every single instance where the incumbent NDPP has acted contrary to our advice, the results have been damaging to the case and to the NPA. It seems, however, that the lesson has not yet been learnt, that it is inadvisable for the prosecution to dabble in matters of politics, even with the best possible intentions. We fear that this instance will be no different. He continues, even if it is accepted that considerations other than purely prosecutorial ones should be considered, which we dispute, the team is nevertheless of the view that to deliberately withhold from the public the fact that a decision has been taken to prosecute the suspects until after the election of the ANC leadership, for reasons which are unconnected with the prosecutorial process, is in conflict with the constitutional duties of the team and the NPA. Now, of course, this was Freudian, and this is the leader of the prosecution team who was very keen to proceed with the prosecution. In 9, he says, we have the greatest sympathy for the acting NDPP's reluctance to be seen to interfere with the due political process that is about to unfold. We also appreciate the concerns relating to public order and stability. These may be particularly fragile now. It is our view, however, that if the decision to prosecute were to be announced in the normal course, as it would be in any other prosecution, the acting NDPP has nothing to fear. The moment the normal processes are deviated from, however, the NPA exposes itself to criticism from one court to another, which will be difficult to rebut. In the present case, there will never be a time when the same concerns will be any less pressing. The prosecution of very serious charges cannot be allowed to be subservient to these concerns. In the end, the prosecutorial imperative enshrined in Section 179 of our Constitution should prevail. This is that the NPA must exercise its functions without fear, favour or prejudice. This is echoed in our oath in terms of Section 32 of the NPA Act, our mission statement and the United Nations guidelines on the role of prosecutors. So clearly he foresaw the difficulties which would arise, and they've come to eventuate, about interfering in the prosecutorial process when one has another purpose, an extraneous purpose, and that is when one dabbles in politics, as it is put. I should add, if I could read just 12, the team feels so strongly about these principles that we have given serious consideration to terminating our involvement in this investigation. Ultimately, however, considerations of loyalty to the NPA and the country have persuaded us otherwise. Now, he saw this interference in his prosecution, which he was ready to proceed with, he saw it in the serious light in which it took place. And he did not know at that stage that McCarthy and Ngcuka had another agenda. He just thought this is being postponed because Polokwane is coming up and don't upset Polokwane and let's wait. He didn't know what the machinations were taking place behind the scenes, which I'm going to come to. Just in context, and with respect, I know that you have this, but can I just say that we're talking about a period from 2005 through to 2009. In 2005, that was when Mr. Zuma was charged by Mr. Pikoli. And in July 2006, a year later, Msimang struck the matter from the roll and the charges were withdrawn. Then we go into the year 2006. That was when the Browse-Mole report was produced by none other than McCarthy, who was head of the directorate. And he was behind the Browse-Mole report, and I will indicate later the relevance and the impact that that report had on McCarthy's thinking and why he was pushing for the postponement of the delay in the institution of the prosecution. In 2007, that was when the Browse-Mole report was leaked to the South African public. Interestingly, it was only in September 2007 that Mshe was appointed, and all these events took place in December. So he didn't have this background. He was appointed September 2007. In November, December, that's when McCarthy and Ngcuka were plotting and the phone calls were being recorded. On the 29th of November, the decision was taken to prosecute. And Dana was happy. Everybody was on board. It was all going ahead. And then the Polokwane conference, we know, happened, and Mr. Zuma was elected then as the ANC president, and he was charged on the 28th of December 2007. In 2008, there was the Nicholson judgment. In September 2008, President Mbeki was recalled and President Motlanthe was appointed. And then in 2009, the SCA reversed the Nicholson judgment, and there was an application for leave to appeal to the Constitutional Court, and the representations were made, and by April, as we know, the charges were withdrawn. I just wanted to give you that context. We've made some additional notes which we'd like to hand up relating to submissions made in our heads of argument. It addresses three issues. It addresses the issue of review, as well as the NDPP's power of review. And it also addresses, insofar as it may be suggested that there are ex post facto reasons, we address those as well. I'd like to start firstly with the approach to review. Mr. Rosenberg said at the conclusion that they're not abandoning the submission that PAJA is applicable, but they rely on rationality and it really doesn't matter. Well, to this point, they still persist that it's a PAJA review, and we say it's not a PAJA review. It's a rationality test based on the principle of legality. And we refer to the case in paragraph 2 of Freedom Under Law and the Director of Public Prosecutions. And that was that arose out of the Murphy J decision concerning Ndluli. It went to the SCA, and Brunt JA said that the PAJA precludes a review of a decision to prosecute, and a decision not to prosecute is the other side of the coin, and therefore PAJA is not applicable. The only basis to review is on the principle of legality. I've seen that they tried to distinguish it. We submit there's nothing to distinguish that case. It's of the same, the decision not to prosecute is of the same genus as a decision to prosecute. And we quote from the decision Brunt J. at the bottom of paragraph page 2, although decisions not to prosecute are in the same way as decisions to prosecute subject to judicial review, it does not extend to review on the wider basis of paja, but is limited to grounds of legality and rationality. The legality principle has by now become well established in our law as an alternative pathway to judicial review where paja finds no application. Thus, there's no merit in the DA's submission. We say that the present case is distinguishable from the full case. And if, so far as they persist with that, we say it has no merit. We say, therefore, they can only challenge on the basis of the principle of rationality. And in paragraph 7, we say decisions of the acting national director are not immune from review by the courts. We know that. Right? But it is only in highly exceptional cases that the court will interfere with such decisions. Now, excuse me. A number of these cases are in our heads of argument, but if you'll just indulge me while I emphasize portions from the judgments. In Butto Star, which is the judgment of Justice O'Regan in the Constitutional Court, she said a court should be careful not to attribute to itself superior wisdom in relation to matters entrusted to other branches of government. A court should thus give due weight to findings of fact and policy decisions made by those with special expertise and experience in the field. We refer to MEC for Environmental Affairs versus Clarison. A review is not concerned with the correctness of a decision made by a functionary, but with whether he performed the function with which he was entrusted. When the law entrusts a functionary with a discretion, it means just that. The law gives recognition to the evaluation made by the functionary to whom the discretion is entrusted, and it is not open to a court to second-guess his evaluation. The role of a court is no more than to ensure that the decision-maker has performed the function with which he was entrusted. Clearly, the court below was of the view that the factors that we have referred to ought to have counted in favour of the application, whereas the MEC weighed them against it. But that is to question the correctness of the MEC's decision and not whether he performed the function with which he was entrusted. It may well be that when one looks at the rationality test, it may well be that when you look at what Mshe heard, what he considered when he heard the tapes, when he considered the representations, it may well be that my lords and my lady may have come to a different conclusion. You might find that it wasn't reasonable. But being unreasonable doesn't mean you're irrational. You're allowed to be unreasonable, and you're allowed to be wrong. The court can't interfere simply because the court would have done something else. And it continues, in Canaland we refer to versus the Minister of Local Government, where Traverso DJP said, when a court is requested to review an administrative decision, the fundamental constitutional principle of the separation of powers is implicated. The separation of powers requires that where the Constitution or legislation has entrusted specific powers and functions to a branch of government, courts may not usurp those powers or functions by reconsidering the issues and making decisions according to their own preferences. This would frustrate the balance of power inherent in the principle of the separation of powers. The primary responsibility of the court entrusted with review jurisdiction is not to make decisions falling within the domain of other branches of government, but to ensure that the relevant branches of government exercise their authority within the limits of the Constitution. And the dictum of Nugent J.A. and Scalabrini is really, with respect, makes the point, where he described what rationality entails as follows. But an inquiry into rationality can be a slippery path that might easily take one inadvertently into assessing whether the decision was one that the court considers to be reasonable. Rationality entails that the decision is founded upon reason, in contradistinction to one made that is arbitrary, which is different to whether it was reasonably made. All that is required is a rational connection between the power being exercised and the decision, and a finding of objective irrationality will be rare. Whether the decision is rationally related to its purpose is a factual inquiry blended with a measure of judgment. It is here that the courts are enjoined not to stray into executive territory. So we just re-emphasize that whilst, if it should transpire, that the court feels that another decision would have been made by this court, it amounts to an interference in the discretion of the office bearer who was entitled to make this decision, and unless it was arbitrary, even if the court finds it unreasonable, the court can't interfere. Can I move forward in these submissions, with these notes we've handed up, and ask you to turn to page 13. Again, we refer to this in order to illustrate the discretion given to a director of prosecutions and to the trust reposed in a national director. The issue with Saint 24 in these proceedings is not whether the acting NDP's decision was right or wrong. Rather, it is whether it was a decision which he was lawfully entitled to make. And we refer to the decision of the House of Lords in Regina Corner House versus the Director of the Serious Fraud Office. I'll bring a copy of the judgment tomorrow. I really didn't think we'd get as far as we have today, and so I only have one copy here, but I'll bring a copy for tomorrow. Now, in that case, the House of Lords referred to the principle on which prosecutorial decisions are exercised by reference to the classic statement of the Attorney General Sir Hartley Shawcross in the House of Commons. He observed, "It has never been the rule in this country, I hope it never will be, that suspected criminal offences must automatically be the subject of prosecution." If I may pause there just to refer, perhaps I could ask you to make a note. It's in the founding papers at page 138 is the prosecution policy that we have. It's in B1. 1B. And I'm reading from the policy, that's our policy. It's at page 138. Perhaps I could ask you to look at bottom of page 137. Bottom of page 137, and this section is on criteria governing the decision to prosecute. The bottom 137, against the letter C, prosecution in the public interest. Once a prosecutor is satisfied that there is sufficient evidence to provide a reasonable prospect of a conviction, a prosecution should normally follow, unless public interest demands otherwise. And 138, there is no rule in law which states that all the provable cases brought to the attention of the prosecuting authority must be prosecuted. On the contrary, any such rule would be too harsh and impose an impossible burden on the prosecutor and on a society interested in the fair administration of justice. And in the middle of the page, there's the heading, the interests of the victim and the broader community. The attitude of the victim of the offence towards the prosecution and the potential effects of discontinuing it. Care should be taken when considering this factor, since public interest may demand that certain crimes should be prosecuted, regardless of a complainant's wish not to proceed. The need for individual and general deterrence and the necessity of maintaining public confidence in the criminal justice system. And the prosecution priorities as determined from time to time whether or not a prosecution would be deemed counterproductive. I emphasize the second bullet point, which is the need for individual and general deterrence and the necessity of maintaining public confidence in the criminal justice system. If I could return then to our note at paragraph 25. So we refer to Regina versus the Director of the Serious Fraud Office. Sir Hartley Shawcross said, "It has never been the rule in this country, and I hope it never will be, that suspected criminal offences must automatically be the subject of prosecution." He went on, My honourable and learned friend then asked me how I direct myself in deciding whether or not to prosecute in a particular case. That is a very wide subject indeed. There's only one consideration which is altogether excluded, and that is a repression of a given decision upon my personal or my party's or the government's political fortunes. That is a consideration which never enters into account. Apart from that, the Attorney General may have to have regard to a variety of considerations, all of them leading to a final question. Would a prosecution be in the public interest, including in that phrase, of course, the interests of justice? Prosecution may involve a question of public policy or national or sometimes international concern, but in cases like that, the Attorney General has to make up his mind, not as a party politician. He must, in a quasi-judicial way, consider the effect of prosecution upon the administration of law and of government in the abstract rather than in any party sense.
But here the decision has already been taken to prosecute in the present instance.
Yes.
The matter before the court, the decision was taken, there would be a prosecution, isn't that so?
Yes.
So this isn't relevant in that instance. That here it seems to me it's before they take a decision to prosecute. But in the present instance, that decision had been taken already.
Yes. The principle will remain the same if I can just demonstrate what the facts were in the Corner House case. The facts in this case were that there was an investigation. The United Kingdom had their own arms deal problems, and there was an investigation which was being conducted into a United Kingdom company. And one of the aspects concerned a valuable arms contract between the government of England and Saudi Arabia. And the Serious Fraud Squad intended to investigate bank accounts in Switzerland and whether payments had been made to an agent of an official of Saudi Arabia. And that provoked an explicit threat from the Saudi authorities. What the Saudi authorities said is that if this investigation continues, they would no longer cooperate with security issues, and this was not long after 9/11, and they would stop negotiations to purchase Typhoon aircraft, and they would stop cooperating with the UK in the Middle East. And when that happened, the Director of Prosecutions decided not to proceed. He succumbed to the threat, and he decided not to proceed. And the applicant brought an application before the High Court for an order directing that he must proceed with the prosecution, and the High Court directed him to proceed. And the matter then went to the House of Lords, and the House of Lords held that the question which it had to determine was whether, in deciding that the public interest in pursuing any important investigation into alleged bribery was outweighed by the public interest in protecting the lives of British citizens, he had made a decision outside the lawful bounds of the discretion entrusted to him by Parliament. That is the question they had to answer. The court held that only in exceptional cases would the court disturb the decision of an independent prosecutor and investigator. That the evidence showed that the director's decision to discontinue the investigation had been taken with extreme reluctance, and although he had consulted with others, he had not surrendered his discretionary powers of decision to any third party, and that this decision had been one which he was lawfully entitled to make. And he submitted there is no basis in law for any suggested distinction between public interest factors which arise from a threat or those which arise from another circumstance. Now, I'm sorry, but do you mean in this application or another application?
In the case that you have referred us to, the case was heard by the court. And in CASU, we are dealing with the review, to review the decision, whether was it rational or not.
So it's a reconsideration by the Acting National Director of Public Prosecutions of the decision to prosecute. It's a reconsideration. Further facts come to light, and the Acting NDPP takes a decision within his discretion to stop the prosecution. And what I'm illustrating is that on these principles, it's his discretion, and the courts will only intervene under the extreme circumstances.
Came into light in this case before.
In the present matter?
Yes.
Well, I'm going to turn to that, because I can't give it to the Lord in one sentence or one answer. But can I at least preview it this way? On the assumption that your Lordship, my lady, finds that there was political interference, that the prosecution process was manipulated by a senior prosecutor together with a former national director for extraneous purposes and unconnected to the prosecution, but for their own political agenda and in order to enhance and advance the position of President Mbeki. On the assumption that you come to that conclusion, the question is this: was the prosecution process tainted to such a degree that the administration of justice would fail if they proceeded with the prosecution? The NPA would be affected to such a degree that the public would lose confidence in the NPA. Now, it must not be minimized, to use the DA's own words. Mr. Rosenberg said that everybody's equal, so we're not talking about presidents, we're not talking about the ordinary man in the street. We're talking about everybody. Nobody must be treated differently. If the country we know, everybody must assume and know that if they are going to be charged, authority conducting itself independently, without influence from anyone else, they must know that there's nobody in the background paying somebody for that prosecution. They must know that there isn't somebody who's got an agenda to prosecute them, that the force being brought about to bear in terms of that process is such that it's independent and there's no other motivation other than to ensure that somebody who may have perpetrated a crime is charged and, if found guilty, then convicted.
Opponent, Mr. Hofmeyer, about what is happening in the NPA. Don't you think that the public would lose trust in the NPA if would lose trust in the system if this matter does not go to court?
I think, with all respect, my Lord, it's actually the opposite, because the public are influenced by what they read in the media. There's no doubt about the sentiment which exists in this matter and has for many years. The merits of this matter don't come into play. Judge, I think Justice Motley asked Mr. Rosenberg earlier. The merits don't come into play. Ordinarily, based on the merits, there would be a prosecution. So we don't deal with the merits. The question is whether it be or may presently or may in the future be the subject of a criminal prosecution. That person is the one who has to also retain faith in the system. And that person must know that he or she is being prosecuted totally independently without justice was so badly affected, that the integrity was so badly affected, that this prosecution could not continue. Now, that's a view he formed. Unless you come to the conclusion that that is arbitrary. You may not agree with it, but that's a view that he formed. And he applied his mind. Hofmeyr and Mzinyati, two senior people. Hofmeyr was the deputy national director. Mzinyati is the director. They serious that it had tainted the whole prosecution. And if this was another case, other than the one with which this country is so familiar over the last many years, perhaps a different view would be taken. But the public, we must do what is in the public interest, not as of what is interesting to the public. We must do what is in the public interest. And that is why I say take precedence out of it. You've got a situation where there was a prosecution, where there was manipulation behind the scenes by the senior prosecutor to achieve his own ends.
But that was only in regards to the timing of when the indictment will be served. Was there any taint to the charges by Downer and Steinberg? And did they know anything about all this? Was it ever discussed with them again before the decision was taken? They didn't know about the decision until the last moment. Why was it not discussed with them once more?
Well, Downer, nobody knew about it until the recordings appeared in. I don't know exactly when they appeared, but McCarthy certainly, when he was getting arranged for this matter to be postponed, because Nuka is saying to him, don't charge him. Whatever you do, don't charge him before Friday. This timing is everything. It wasn't just the timing. Would it make a difference to the merits, whether he was charged in December or January? The answer is no. But by charging him later than they intended, that would have a difference to the outcome that the prosecutor intended to achieve at Polokwane, because he was of the view that if Mr. Zuma was charged in December, I see Mr. Omar says President Zuma behind me.
Sorry, please defer to our learned president. We call him President Zuma. As a learned colleague, each time I refer to President Mbeki, it's President Zuma. He's the current president. He's serving our people for the second term of office. I'm humbly asking everyone here, please refer to my president as President Zuma. Siyabonga. Thank you, man.
Lords, unless you direct me otherwise, it takes it out of context. He wasn't the president at that time.
No, but I've recommended to everybody that I think maybe for the sake of respect for the office, let's refer to him as president.
You may want to say the third respondent. I see Mr. Rosenberg ended up doing that, because then at that time when these things unfolded, he wasn't the president of the country.
Yes.
So you'll be safe to say the third respondent.
I couldn't be talking about the prosecution of President Zuma in 2007. He wasn't the president, right? Yes. But I'll try the third respondent.
Yes. But we just want the public to have confidence and to see that the courts are respectful to the litigants who are before it.
I just don't want it to be thought, if I say that he was charging President Zuma in December 2007 when he wasn't the president. But I'll take it.
Let's proceed and not waste more time on this issue.
No, I was dealing with timing.
Yeah, you're still answering the question raised by my sister there. You see, you used the phrase process was contaminated. And when we read the reasons by Mr. Mpie, he confines the contamination to the timing of the service of an indictment. Now, to what extent that can taint the entire process of prosecution is what I'm interested in knowing from you. Because if the reason was that the objectives that the other two gentlemen are alleged to have had was to influence the outcome of the election, through the timing of the service of the indictment. The real question is, how does that then affect the entire prosecution?
So our submission is that timing is everything, because the whole idea behind delaying it, where Mr. Downer said, we are ready, we must proceed, this is going to come back and bite us. Don't delay it for political reasons. We must proceed. And it was being delayed for one reason only, and that was for a political purpose. And that is why the timing matters. It doesn't matter to the merits of the case. Let me try and explain it this way by giving an unconnected, unrelated, exaggerated example. Assuming there's a prosecution in the magistrate's court in a particular jurisdiction, and there's a good, solid case which the prosecutor believes he has against an accused, but somebody who's the complainant wants to ensure that it happens more quickly, and he goes and he bribes the prosecutor. To say, well, it doesn't affect the merits, ignores the fact that the process has been abused. That is the problem. The NPA must remain squeaky clean. We know it's been dysfunctional over the years. We know there are problems within the NPA. We know about all the infighting. Nobody can get away from that. But to say that because the NPA is not squeaky clean, it doesn't have to now try and restore its own integrity, ignores the problem. The problem is that the person who was running with this prosecution had his own agenda. It was a political agenda. That's why timing matters. It doesn't matter to the merits. Whether he'd been charged in December or January wouldn't have made an outcome, had an outcome in terms of the merits. And then when Mshe sees what his senior prosecutor has been doing and how he's been delaying it and the reasons why he was delaying it, he says this process has been tainted. And I come back to this, then I can only, not to sound like an old broken record player for those who remember those things, it's not whether you think that that's a decision you would have taken. You may not have. The question is it irrational? It may be unreasonable. But he says, when he starts his reasons, he says, this is one of, if not one, I think this is the most difficult decision I've had to make in my life. Because he's thought about it. And he knows he doesn't want the prosecution not to proceed. He would prefer the prosecution to proceed. He says, I stand before you today to announce the most difficult decision I've ever made in my life. It was not an easy task at all. I had the privilege of having listened to inputs and comments of very eminent jurists of the NPA, and I'm thankful to them for their candid and frank arguments. When I was interrupted earlier, I was saying that the persons who agreed with Mshe were Hofmeyr and Mzinyati. Hofmeyr was a deputy national director, Mzinyati was a director. They appoint presidential appointments. They hold high positions. They took a view. They were aghast at what had happened as well. And they discussed that. And Hofmeyr confirms on an affidavit where he says, we all agreed. I think earlier on, Justice Motley, you asked whether, but they had agreed.
You have printed out a picture of the two gentlemen, Messrs. McCarthy and Mr. Nuka, having an agenda of their own, seeking to postpone for the reason of that agenda to manipulate the outcome of whatever was taking place in Polokwane. That I understand. But now the facts here point out, and I'd like you to address me on that the decision that the indictment must be served after Polokwane was taken by Mr. Mche himself. And if he took that decision, the reasons that were raised were that he was concerned about what may become a public fallout with that. I don't know if you follow what I'm saying.
I follow what you're saying.
Yes, his reasons have nothing to do with the manipulation of the outcome, but his reasons that took into account what was happening at that time. And that's what we get from Hofmeyr's affidavit. That, well, he says, Hofmeyr could to say that he was influenced by McCarthy to do so, but that's something else that we'll go into. But at this point in time, the decision not to serve the indictment before the Polokwane conference, was it taken by McCarthy or was it taken by Mche? If it was taken by Mche, then you will have to address us on that as to what was his agenda.
My answer is going to be, when I go through the facts, that it was a decision of McCarthy to which Mche deferred. He didn't like it, but he deferred to it, and he says so in his affidavit, and he then conveyed that to Downer. But it really was a manipulation by McCarthy to get Mche to agree to the postponement. And that becomes clear when you have the affidavit of Hofmeyr saying that he had been approached by Mche about postponing the matter, and that Mche then confirmed to Hofmeyr that he too had been lobbied by by McCarthy to postpone the matter. And finally he said to McCarthy, I'm not in agreement with you, but I will go along with it. And then what happens is McCarthy phones Downer, and McCarthy represents to Downer, he lies to him, and he represents him that he is aggrieved by this decision about the postponement, and he didn't want to postpone, when it's quite clear that he was the driving force behind the postponement all along. So it really was Mche who'd come on board in September. McCarthy was running with this prosecution. He was managing it, and Mche says on affidavit, I didn't want the matter postponed, but if it was McCarthy's decision, I went along with it, and he explains that he then conveyed it to Downer. So,
Where do you find this? Mche says that.
I'm going to ask you to look at Mche's affidavit, which is in volume 34, I think it is. The volume 34 at page 3186, I think it says. And just pull out Hofmeyr for me at once, at page, at Hofmeyr, page 172. So at page 3188, this is Mche's supplementary affidavit to which there's been no response, no reply. It's not contradicted. He's at 3187, there's a heading, McCarthy's attempts to persuade me that the prosecution should be delayed. 5. I do not remember the exact date at which McCarthy spoke to me about delaying the announcement of the MPA's decision. I do recall, however, it was shortly after November. Although McCarthy was on leave for much of the period, he did come to Pretoria at various meetings. He was in Pretoria during the period 30 November to 6 December. They looked at the cell phone recordings, he goes on to say, and they determined from the cell phone, when the cell phone call is made, and he was in Pretoria. And that's why he says at the top of 3188, it includes all, he refers to Steyn, who established McCarthy was where he was. The applicant contends that McCarthy was in Cape Town during the period. For this reason, it maintains that McCarthy could not have spoken to me about postponing the Zuma prosecution. Steyn's examination proved otherwise. Paragraph 10. McCarthy had a habit of just coming into my office if he wanted to discuss something with me. He did not wait to make a formal meeting. He came to my office and told me that he wanted to talk to me about postponing the Zuma prosecution. I did not initially support McCarthy's view that it was necessary to postpone the Zuma prosecution. I was aware of the prosecution team's views. I knew that they were anxious for the prosecution to commence as soon as possible. In the criminal trial, both President Zuma and the presiding judge had criticized the MPA for delays in finalizing the investigation. We anticipated that once President Zuma was charged, he would launch a stay application. The delays in finalizing the prosecution were bound to be an issue as they had been in the past. We knew that any further delays in finalizing the prosecution would count against us in the stay application. I knew that the prosecution team felt strongly that any delay in announcing or commencing the prosecution was likely to have serious consequences in future proceedings and would be portrayed as an attempt by the MPA to manipulate the case. Then 12, the decision to prosecute had already been made. It was made on 29 November. On that day, the prosecution team made a presentation to the deputies meeting, which they recommended that the charges against President Zuma include a charge of racketeering. The recommendation was accepted. I asked the prosecution team to prepare the Section 33 report to the Minister on my behalf. They sent me the report on Monday, 3rd December. It was recorded that the decision to prosecute President Zuma had been taken and that the prosecution would be instituted as soon as possible. To delay it. That is no reason related to the prosecution itself. Initially, I did not agree with McCarthy that the prosecution should be postponed. His suggestion came out of the blue, as it had never been mentioned to me. At the time, I was not aware that McCarthy had spoken to Down and Hofmeyer about delaying the prosecution. Nevertheless, I accepted that McCarthy had the authority to make the decision. He felt engaging in any serious debate with him. McCarthy was in charge of the investigation of prosecution. I did not have the authority to instruct him otherwise. That meant that he could decide when to institute the prosecution. I made it clear on more than one occasion that all decisions related to the Zuma prosecution would be left to McCarthy and his team, and that I and the other deputies would only give input and indicate our views. This was because McCarthy was under no legal obligation to consult me or to take account of my views. McCarthy told me that it would be harmful to the NPA, particularly the DSO, which was under severe attack at the time if Mr. Zuma was prosecuted before the Polokwane Conference. He believed that if he were to be charged before the Polokwane Conference, it would destabilize the DSO and the NPA in the country. He was wrong when he thought that he didn't have the power to overrule McCarthy. He did. But that was the view he took at the time, and he guided himself based on that.
So if it means then what is stated in the notes of Mr. Downer, that he told him that the decision to prosecute should be stayed until after Polokwane is his and no one else's. What are we to do with that statement?
I think he explains it. If I can just find that. At paragraph 25, I met with them, 24, I met with the Minister during the evening of 5 December. I raised with her the issue that the announcement would possibly be delayed. It was clear to me that she agreed that the prosecution should be delayed. She was concerned that the NPA would be perceived as targeting Mr. Zuma ahead of the Polokwane Conference. The following day, 6 December, I telephoned Downer to inform him of the decision to delay the prosecution. I told Downer that I had taken the decision to postpone the prosecution independently. I told him that it was my decision and my decision alone. I did so because Downer was aware that I had met the Minister the previous day. I did not want him to think that the Minister had interfered or that the Minister had unduly influenced me. I did not tell Downer that it was McCarthy who had persuaded me that it was necessary and that delaying the prosecution was the better option for the NPA. I knew that the decision to delay the prosecution was likely to be unpopular. I knew that Downer would be unhappy with that decision. And he also says, as the head of the NPA, I felt that I had to support the decision. McCarthy had already made the decision. I did not want to blame it on others when I knew it was likely to be unpopular. As expected, Downer was angry about the decision to postpone the prosecution. Yes, I should complete the picture. At paragraph 28, Chair says, soon after my conversation with Dana, I went on leave. My last day was on 14 December. I was due back at work early the following year. When I went on leave, I was under the impression that Mr. Zuma would be prosecuted in the new year. It's just in Hoffman's affidavit, he just confirms that everybody wanted the prosecution to proceed. Everybody thought it was going to proceed, but McCarthy was lobbying behind the scenes. And once the prosecution was delayed, and as soon as Polokwane was over, and Chair says at paragraph 29, on 19 December 2007, following President Mbeki's defeat to Mr. Zuma, McCarthy decided to institute the prosecution. We know this because on 19 December, he told Ngcuka that he hoped to be able to, quote, move by Friday, i.e. by 21 December.
He did not decide to institute the prosecution. He decided to serve the indictment. The prosecution's decision had been taken long ago.
Yes.
It had come and gone already.
I with respect, accept that. We're talking about the indictment.
Yes.
Yeah. And Chair says he did not consult me, made the decision independently. He knew he had the power to do so, and he did. So straight after Polokwane, when he says we've got egg over our faces, we're bleeding, and then he immediately takes the decision to serve the indictment. And Chair doesn't know this, because Chair gives an interview to Radio 702, and he's asked, when are you going to institute the charges? And he says, in the new year. And then he gets a telephone call from McCarthy to say, what are you talking about? I'm going to charge him right now. And Chair was annoyed. He said, I've now made a fool of myself to the public. I've told them it's next year. In the meanwhile, it's going to happen immediately. And it does happen immediately. The point of this is McCarthy is central to all of this. McCarthy is the person who's managing this entire prosecution. Now, when the representations were made in 2009 to the NPA, first oral representations were made, and various matters. Written representations and then oral representations were made, but the recordings were not produced immediately. The NPA were told that there are recordings, but they were not yet produced at that time.
In the Browse-Moore report.
I'm sorry, I didn't hear. Which stage?
I'm saying before the tapes were produced, Mr. Mche knew that McCarthy was also involved in respect of the Browse-Moore report. And then at that stage, before the production of the cassettes, that did not persuade him to discontinue with the charges.
No, that stage not.
Yes.
At that stage not. The Browse-Moore issue was raised when the representations were made. When the oral representations were made, Hoffman says that amongst the issues which were raised was the Browse-Moore report. Before
the draft letter was written. The Browse-Mole report was considered with all the other representations at the time.
Except the recordings
Except
had
the
not yet been
recordings, yes,
listened to.
because they were not available yet.
Because Hofmeyr says, that page starts, Zuma representation starts at 235, President Zuma. It says at 237, paragraph 243, Hulley disclosed that he was in possession of recordings of conversations between McCarthy and various politicians, including Ngulka, Zeeb Kumalo, and Ronnie Kasrils. He maintained that the recordings proved that McCarthy manipulated the timing of the decision to charge the third respondent and that he had deliberately delayed the decision until after Polokwane, with one purpose in mind, to undermine the third respondent's chances of being elected as ANC president at Polokwane. Following the third respondent's election and President Becky's defeat, McCarthy had moved with haste to charge him. And then at 246, Hulley and Kemp related further of examples that they had linked individuals in the NPA past and present to a conspiracy to discredit the third respondent. And they included Nuka's announcement in 2003 that he had decided not to charge the third respondent along with Sheikh, and in 246.2 the fact that McCarthy used the resources of the NPA and the DSO to source negative intelligence about the third respondent. That points specifically to McCarthy's role in the Browse-Mole project, which was an intelligence gathering project.
That we wanted to put forward was that before Mr. Amche took the decision on the first, he was aware that McCarthy was also involved in the Browse-Mole report. And when they discussed with the team, the decision then was that the prosecution would continue.
From the draft letter?
Yes.
Yes, the draft letter implied that they were going to reject, it implied, this is a draft letter, that they were going to reject the representations. I think even Hofmeyr says they were not signed, they were not under oath. But importantly in that draft letter, if I can just go to it, it's D7. I can just have a moment to find one. D7. Appropriate place where he says. It's right in front of me. Thanks. At paragraph 5 at D13, there is reference to alleged political conspiracy and abuses of process. This aspect of your representations has occasioned great anguish. About 4 lines down, I'm firmly of the view, therefore, that these allegations are not matters to be suppressed and concealed, but rather ones which must be vigorously and transparently investigated and determined. Although I'm advised that the material to which you granted Mr. Hofmeyr and Advocate Mzinyati access seemed to them to be authentic and reliable, that has not been established conclusively and can only be done if and when the original material is made available for detailed examination. Moreover, the manner in which the material was obtained and or passed on to your client and to you to be used for his benefit and the legality of actions of all those involved are unknown. These matters too must be the subject of further investigation. So at this stage, they were still coming back with further representations, and he had, and certainly Mshe had not yet listened to the transcripts. This is, I think, early March. He only listened to them on the 31st of March. There's no date, but he only listened to them on the 31st of March. I hadn't applied my mind to this letter before it was raised this morning, so I'd like another opportunity to look at it. But I think this letter was drafted by Mr. Downer and not by Mshe. Yes, this was the... Mr. Manechi points out, this was the recommendation to Mshe by Downer.
Downer as an individual alone.
No, he was the head of the prosecution.
But this letter was also taken to advocate Trengove by Hofmeyer and another person. So it's not only Downer who was involved in it. It was taken to advocate Trengove for him to make corrections.
But ultimately, it's got to be Mshe's decision. Other people are drafting it, and he hasn't listened to the tapes yet. We submit that when one considers the role of McCarthy, one can't look at McCarthy's role without looking at his background and his involvement with the Browse-Moll report. We've said that the whole motivation behind McCarthy's actions, from his point of view, was to support President Mbeki and to ensure that he was successful at Polokwane. And one understands that. That's why I say that when one interprets the conversations, it's done in context. It's done with knowledge of the background of why he was doing this, why he was saying the things that he was saying. And that context comes from the Browse-Moll report. It might open old wounds, but we're looking at what happened at the time, and it's important. And that was the report, which the report is in the bundle at page 874. Not bundle, it's in volume 10 at page 874 was the report. And then there's the report of the Joint Standing Committee on Intelligence, which is at page 908. But it's important as to what they said about McCarthy in that. And you recall that the report contained allegations that the third respondent was involved in a conspiracy which was a threat to the sovereignty and integrity of the South African state, and said that the president of Angola...
But despite that, the prosecution decided still going to proceed up to until after Mshe listened to the tapes.
Yes.
So I want to understand from you, what is the relevance of you quoting to us what happened regarding that report?
The relevance is clearly that to show that McCarthy, from as far back as the Browse-Moll report, when it was recommended that steps be taken against him, when steps weren't taken against him, when Picoli told him to stop and he didn't stop, and there's a very serious criticism of his conduct. And this whole process in the Browse-Moll report, everything he was doing there was aimed at trying to prevent the third respondent from taking over from President Mbeki. So since 2006, McCarthy's role has been to try and create conspiracy.
For the court, before Judge Nicholson, this report formed part of the record before the SCA, and still thereafter, the team decided to proceed with the prosecution. Now, do you want that it should be given another weight in this decision?
With respect, well, that's not the point.
Well, what is the point?
The point is that one is looking at why McCarthy arranged for this the service of the indictment to be delayed. Why did he do that? A decision had been taken on the 29th of November to prosecute the third respondent. That decision was taken. But he's not prosecuted until he gets served with an indictment. There may be many people who are out there who are about to be prosecuted and they don't know it, where a decision has been taken. The fact is that he is only prosecuted when he gets the indictment. And now you've got McCarthy, for his own political reasons, delaying the decision. He's a prosecutor. He's supposed to be above reproach. He's supposed to show complete and utter integrity. He is the beacon of the National Prosecuting Authority. He's prosecuting one of the most high-profile people in the country at the time. He has to show complete and utter integrity with him and with everybody else. And behind the scenes, what he is doing is he is manipulating when the charges are brought. And he's doing it to make sure that President Mbeki gets elected at Polokwane. That's what he does.
Sit with your nose. I'll try not to interrupt you.
I just needed some clarity on this last point. The point that has been raised is that prior to the 1st of April, when the decision was taken, all this information that you are taking us through was known to Mr. Mche. It was known. And it's not that it's something he discovered after listening to the tapes, that there was a Browse Mole report. He knew it before then. And he was part of the decision to say, we are proceeding with the prosecution, notwithstanding the information we have. Now, what we don't have before us is, after being briefed by Hofmeyr and Zinyati about the content of the tapes, when he himself listened to the tapes, we are not told what is it that is new which he found there that caused him to change his mind not to continue with the prosecution. We are not told that. He listened to the tape knowing what the contents were because he had been briefed. He listened to the tape knowing that Mr. McCarthy was involved in the Browse Mole some months before. He did that. But right up to, according to Hofmeyr, right up to that moment when he had to listen to the tape on the evening of the 31st of March, he was of the view that the prosecution should proceed. What we miss here is what made him change his mind, which he did not know before. That is the question that my brother here is raising.
I've clearly not been successful yet in conveying to you the relevance of the tape recordings, which don't stand alone. They do not stand alone. The only, when it was put to Mr. Rosenberg earlier today that interpretation is a matter for the court, it can only be considered and interpreted in the context. And what is the context? The context is what was known to Mshe when he listened to those tape recordings. Those tape recordings listened to by somebody else may have had a completely different meaning if they did not know the background to the Browse Mole report and what Mshe himself knew. Everything fell into place for him once he'd heard the tape recording. That is why he says that he was shocked. Hofmeyr says he was shocked. Mzeniati was shocked. They were all shocked as a result of the tape recordings, because I think Hofmeyr was familiar with the Browse Mole report. So it is the context. What do those tape recordings mean? They mean everything when Mshe listens to them and knows what he does know about the Browse Mole report.
Who doesn't tell us that, Mr. Epstein?
Where
do we find that in the papers? Where does he tell us that with everything I knew about the Browse Mole report and the McCarthy trying to delay the service of the indictment and listening to the tapes, all that falls in place. I don't know where we find that in the papers.
Well, Milady, if one is looking to say that when you read his media statement, it was not his all his reasons. That's his media statement that he put out. If one is looking for everything in there, one may not find it. But if you read it with what is said in the affidavits, then it raises the question, is this ex post facto? No, it's not. Now, what I'd like to do is I would like to say that he is not bound, he's not tied to exactly what is stated in the media statement as the reasons. They can be expanded upon. And this isn't a Pudger review where one is entitled to ask for reasons and reasons must be furnished. This is a rationality review where reasons were given in the media statement and he's entitled to expand on them as long as they are not ex post facto, thought up afterwards reasons. And we submit that when you look at what is said in the affidavits, they are not thought up afterwards. And in fact, may I Yes, importantly on this very point, Mr. Manetti refers me to Hofmeier's affidavit at page 247, paragraph 269. 269. Where he says, Mshe felt betrayed by McCarthy. This is after he's now listened to the recordings. Once he heard the recordings, he realized the extent to which McCarthy had manipulated him and others in the NPA. He understood then that McCarthy's insistence that the institution of the prosecution be delayed was not innocent. Rather, it was politically motivated. McCarthy had abused his trust. He had manipulated him to ensure that the prosecution was delayed. He had reluctantly agreed. And then when it no longer suited him and others close to President Mbeki, he had finalized the prosecution contrary to the wishes of Mshe. Mshe was also struck by the disrespectful jibes that McCarthy and others made about him and Hofmeier when he spoke about them to others. So that is what fell into place for him. He states that now he realized what was going on. I wanted to refer in the document which I handed up to you. I wanted to refer to the new what we call the new reasons argument, which is at page 7. We say there's no impediment to providing additional reasons where they are not ex post facto reasons and accordingly not the reasons it should be for. No, sorry, not two reasons for the decision. I'm reading paragraph 12. The DA submits that it is not open to the NPA, quote, to remedy Mshe's decisions by putting up additional new reasons in an attempt to redeem the decision. For this submission, the DA relies upon the authorities set out in paragraph 76 to 78 of their heads. The applicant invokes Jikama, which was cited in the National Lottery Board case, where Kachalia J. stated the question here is not whether there were other reasons in the record that justified the board's decision, but whether it could give reasons other than those it gave initially for refusing the application. The decision in the lottery case was obiter. Then we say what the binding law is. The binding law is in paragraph 16. It's the case of Van Zyl versus the government of the Republic. Here the appellants argue that the government was disallowed from advancing a new reason, namely the influence of policy considerations in its answering affidavit, not to be found in correspondence between the parties prior to the launching of the application. On the facts, the appellants had requested the government to provide diplomatic protection against the government of Lesotho after the cancellation of mineral leases. Harms wrote, the government obtained legal advice from different persons. It held meetings with Mr. Van Zyl and his delegation of lawyers and international legal experts. Inter- and intra-departmental memoranda were prepared. The government considered the request carefully over a period of time, and he made a policy decision, first by the Deputy Minister, then by the Minister, and eventually by the President himself, who twice considered the matter. And then the applicant urged that overarching policy considerations not mentioned in the correspondence prior to launch the application constituted new reasons. And rejecting that argument, Harams J.A. held the case should come on which the appellants rely for the principle that an organ of state is not entitled to raise new reasons for administrative decision and an answering affidavit was one where the new reasons were ex post facto reasons and accordingly not the true reasons for the decision. So hence the point in paragraph 17, we say the point is not whether or not all the reasons appeared in the correspondence prior to the litigation, but whether these were in fact pretexts which in fact played no part in the decision-making process. And in footnote 22, if I can refer you to that, there's reference to the case of Hijazi versus Kensington Council. Nothing objectionable in a decision maker making a subsequent statement in which he identifies the material which he took into account in the course of the decision-making process. And then we refer to Bistorm, judgment of Skippers J. That distinguished case of Jikama. There's reference to the English authorities at paragraph 20. I don't want to delay the court on that. And paragraph 21, we make the point that this must be seen in the context of the fact that this is a judicial review in terms of the Constitution, and there's no statutory obligation to furnish reasons. The statement made by the ANDPP of 6 April was a media statement. It was not the equivalent of a response to a request for reasons in terms of Paja. It must also be remembered that there were confidential elements that had been conveyed to the ANDPP when the representations were made. And further in this regard, the court in review proceedings will approach the manner in which an administrative authority has chosen to give effect to its duty to furnish reasons with the institutional committee. The Minister of Education versus Bovellon, it was held that so long as the gist of the reasons was conveyed, the provincial MEC was not obliged to spell out why particular schools were considered for closure. And finally, Young Men Shan versus Shagan, the mere fact that the tribunal did not mention in its ruling every fact or circumstance that it took into account does not warrant a review of that ruling. Sometimes even the briefest of reasons suffice. And Canaland, finally, Traverso GJP, having held that a court must defer to the MEC's decision on the merits, went on to reject the municipality's complaint about the explanation offered by the MEC. He had said little more than that the evidence did not justify guilty finding. Despite describing this as terse, the court did not disturb the decision. So the point is that it doesn't have to be that every single thing was stated in the media statement is the precise reason. And clearly, I mean, we know that even judges consider matters, do a judgment, and sometimes there's a purported application to appeal on the basis that a judge didn't mention a particular point. Well, the judge doesn't have to. Doesn't mean that this is not mentioned, that it wasn't taken into account. So we submit that the reasons given can be read together with the affidavit of Hofbauer. I am going to.
It's 4 o'clock now. Have you
No.
made submissions that you wish to make on the point that you are on?
No, there'll be a new plan.
There will be a new point. And I think it would be appropriate to attend. We'll commence tomorrow at 10 o'clock. Court adjourns.
All right.
But the boards, we're going to leave the boards here. Yeah, I can
put them back.
Okay.
I'll start again.
Can you tell pt2?
Yampata. Urbata. 1, 2, 3. Takan. Takan.